A mother spends her whole life saving. She works 2 jobs. She skips vacations. She clips coupons. She raises 3 children, sends them all to college, and finally, at age 78, she has $187,000 sitting safely in her checking and savings account. It's the money she promised herself she would leave equally to her 3 children when she's gone. She writes a will. The will is clear. Divide everything equally among my 3 children, Margaret, David, and Susan. 6 years earlier, she added Margaret, her oldest daughter, to her bank account, just for convenience, so Margaret could help her pay the cable bill and the property tax when her eyesight got bad. A simple kindness. A small piece of paper signed at the local branch. Then one quiet Tuesday morning, the mother passes away peacefully in her sleep, and within 48 hours the entire $187,000, every single penny, legally belongs to Margaret. Alone, forever. David and Susan get nothing from that account. Not because Margaret was greedy, not because the will was wrong, but because of one tiny, devastating banking rule that almost no senior in America understands. If your heart just skipped a beat, please don't go anywhere, because what I'm about to share with you in the next 10 minutes could literally protect your children, your grandchildren, and your entire life's savings. Hello, my dear friend. I am Artur. I'm a senior policy analyst, and I have spent years helping retirees just like you decode the rules that banks and government agencies don't put on the front page. Today, on Senior Pension and Benefits Hub, I'm going to expose a banking rule confirmed by the Consumer Financial Protection Bureau and AARP that has destroyed more families and more inheritances than any other rule in America. I'll explain exactly how this rule works, why your will cannot protect you from it, and the 3 simple legal steps you can take this week to fix the problem before it's too late. And please, please, stay with me until the very end, because there is one hidden mistake I see seniors make almost every single day. It is the silent killer of family inheritances. I'll reveal it in the final minutes of this video, and once you know it, you'll wonder why nobody ever told you before. So pour yourself a cup of coffee, get comfortable. Let me tell you about Eleanor. Eleanor is 76 years old. She lives alone in a small house in Pennsylvania. Her husband passed 8 years ago, and since then, her 3 grown children, Margaret, David, and Susan, have been her whole world. Margaret lives just 20 minutes away. She visits every Sunday. She picks up groceries. She drives her mother to doctor's appointments. She is, in every way, the dependable one. So 3 years ago, when Eleanor started having trouble reading the small print on her bank statements, she did what so many of you watching this video have done. She walked into her local bank branch with Margaret. She told the teller, "I'd like to add my daughter to my account so she can help me with bills." The teller smiled, slid 2 forms across the counter, and asked them both to sign. Eleanor didn't read the fine print. Margaret didn't read the fine print. The teller said, "All done. Have a nice day." And in that one moment, that simple, well-meaning moment, Eleanor unknowingly disinherited 2 of her 3 children. Because here is what the bank did not explain. When you add another person to your bank account in the United States, the default arrangement at almost every bank in this country is something called joint tenancy with right of survivorship. The Consumer Financial Protection Bureau confirms this directly on their website. The CFPB says, and I quote, "Most joint bank or credit union accounts are held with rights of survivorship. This means that when one account owner dies, the money passes to the surviving owner." Notice what that does not say. It does not say the money is divided according to your will. It does not say the money goes to your estate. It says the money goes to the surviving owner. Period. This rule overrides your will. It overrides your trust. It overrides every spoken promise you ever made at every Thanksgiving dinner. It is a contract between you and the bank, and the moment you die, that contract executes itself, automatically, instantly, and irreversibly. Eleanor's will said, "Divide equally," but Eleanor's bank signature card said, "Joint with right of survivorship." And in any court in America, the bank signature card wins. When Eleanor passed away last spring, Margaret was devastated. She loved her brother and sister. She fully intended to share the money equally, just as her mother had wanted. So she sat down with David and Susan and explained what had happened. David was furious. Susan was heartbroken. And then something else happened. Something Margaret did not see coming. Margaret was in the middle of a difficult divorce. Her husband's attorney heard about the inheritance, and he filed papers in court arguing that the $187,000, now legally Margaret's, was a marital asset subject to division in the divorce. Half of Eleanor's life savings ended up in the hands of a son-in-law she didn't even like. I tell you this story because I do not want it to be your story. So let me explain, in plain English, exactly what every senior with a bank account needs to understand right now. There are 4 facts you must know. Fact number 1, when you add another person to your bank account, you are not making them a helper. You are making them a co-owner. Today, right now. AARP says it very clearly. When you do this, you've given them access to your funds not just after you pass, but today. That child can walk into the bank tomorrow morning and withdraw every dollar without telling you. It would be completely legal. Fact number 2. The right of survivorship is automatic and overrides your will. The CFPB confirms this. When you die, the entire account balance goes to the surviving co-owner immediately, outside of probate. Your will has no power over it. Your trust has no power over it. Your other children have no legal claim. None. Fact number 3. Adding a child as a joint owner exposes your money to the child's creditors, the child's lawsuits, and the child's divorce. If your son gets sued because of a car accident, your money is at risk. If your daughter files for bankruptcy, your money is at risk. If your child is going through a divorce, your money can be split in half in family court. None of these things have anything to do with you, but your money pays the price. Fact number 4. Joint ownership can also cost you Medicaid coverage. If you ever need long-term nursing home care, Medicaid looks back 5 full years at every financial move you made. Adding a child to your account can be treated as a transfer of assets, and Medicaid may delay your eligibility for nursing home benefits by months, sometimes years. That delay alone can cost a family more than $100,000. Now, here's the good news. There are safer, smarter, completely legal ways to let your child help you with money without giving up control or risking your inheritance. Let me give you 3 exact actions you can take this week. Step 1. Call your bank this week and ask one simple question. How is my account currently titled? Is it joint with right of survivorship, or is it something else? Write down the answer. Most seniors have never asked this question. Most have no idea what their signature card actually says. You have the right to a copy of your account agreement in writing, and the bank must provide it. This single phone call could save your family from years of pain. Step 2. Replace joint ownership with a payable on death designation, also called a POD. This is one of the most powerful, least-known tools in American banking. A POD designation allows you to name one beneficiary, or many beneficiaries, who will receive the money only after you pass away. While you are alive, you keep 100% control. Your children have no access. They cannot withdraw. They cannot drain the account. Their creditors cannot touch it. Their divorces cannot reach it. And the money still bypasses probate, meaning your children receive it quickly, without lawyers, after you are gone. You can name all 3 of your children equally on a POD form. You can change the beneficiaries at any time. It is free. It takes 15 minutes at any bank branch, and it is recommended by both the FDIC and AARP. Step 3. Sign a durable power of attorney for finances. This is the document you actually need if your child needs to help you pay bills. A durable power of attorney gives your child the legal authority to act on your behalf, write checks, pay your property taxes, talk to Social Security on the phone, without making them a co-owner of your account. You keep 100% of the ownership. They get the helping authority. When you pass away, the power of attorney ends automatically, and the money goes to whoever you named on your POD or in your trust. Many banks require their own specific power of attorney form, in addition to one drafted by your attorney, so call your bank and ask which form they accept. Do this before you need it. Do not wait until you are too sick to sign. Now, before I let you go, I promised you one final, hidden mistake. This is the mistake that destroys families more than any other. Please listen carefully. Here it is. Many seniors think, I'll just add all my children as joint owners to be fair. Please do not do this. AARP and the American College of Trust and Estate Counsel both warn against this strongly. Because when you add multiple children as joint owners, every single one of them has unrestricted access to the entire account. Any one of them can walk into the bank tomorrow and withdraw every dollar without telling the others, without asking permission, without breaking any law. And once that money is gone, the other siblings have almost no legal way to get it back. Even worse, if any one of those children gets sued, gets divorced, or files for bankruptcy, the creditors can come after the entire account balance, not just one share. You have not created fairness. You have created 6 different ways for your money to disappear. The answer is never, add more children to the account. The answer is always, use POD beneficiaries or a revocable living trust. My friends, this is one of the most important conversations a senior can have. The banks will not warn you. The tellers are not trained to explain the difference between joint accounts and POD accounts. The CFPB exists, but you have to ask. The information is there, but nobody hands it to you. So please, do not rely only on YouTube notifications for important updates like this. Go directly to the official sources, consumerfinance.gov for banking questions, AARP.org for estate planning, Medicare.gov, and SSA.gov for your benefits. Bookmark them. Check them once a month. And if something on those sites confuses you, call a free legal aid clinic for seniors. Many states offer them at no cost. If this video helped you, if you learned even one thing today that could protect your family, please share it with another senior in your life. Send it to your neighbor. Send it to your sister. Send it to the friend from church who just added her son to her account last week. Because the truth is, most seniors will never hear this warning until it is far too late. I am Artur. Thank you for trusting me with your time today. Take care of your family, take care of your money, and I will see you in the next video, right here on Senior Pension and Benefits Hub.